Hi guys, it's Kathy. Remember me? Hope you're doing well. Man, it's been a while. 16 hours. That's how many hours straight I sleep if my power goes out. 16 hours. Okay, we are going to start with Judge Wolf today because he does something that I cannot believe. I've not seen before. I can't believe it worked. But that's where we're going to start. Let's get to it.
Okay, we are ready to go. All right, we've acknowledged that we're going to go ahead and have this live streamed, and both parties are in agreement with that. But at this point in time, the only other thing I would do would be to address one issue. At a prior hearing, I made the statement that I knew Ms. Wallace. Ms. Wallace, I represented your husband, I think, in a divorce action many years ago. Is that correct?
It is correct.
So you would have the right to challenge my hearing this case, and court won't hear cases where there's an issue that involves a possible conflict of interest. If you have any objection to me hearing your case, then I would like for you to state that here on the front end so we can get a special judge to come in and hear it. So.
No, sir, I have no conflict. That was many, many years ago.
Well, the reason I wanted to address
You are a special judge, Judge Wolf. You are.
that is because Mr. George had, in one of his subsequent pleadings, I think, made some mention of the fact that I acknowledged that I know who you were. Of course, you were formerly or may still be the chief of police.
No, sir, I retired.
You retired as the chief of police. All right. Now, Mr. George, then we are ready for you. This is the hearing on number of motions, but essentially what this is for you to demonstrate to the court your claim for adverse possession, because all of your other motions arise from your claim of ownership by adverse possession. So we're going to need to establish that first, but it is your case and I can't help you try your case. You'll have to put on your proof and do what you think is appropriate. So if you're ready to, you want to make any sort of opening statement, I'm familiar with.
Please, Your Honor. Thank you so much. I really appreciate you stating what you stated. I was not prepared for my actual adverse possession case. I didn't understand what all other motions would be heard. My very first one, you signed off that there was the ex parte was declined, and then I was going to have my quiet title on the December 1st hearing. And when I got here, it was only for ex parte, so I wasn't prepared for that because I was prepared to deliver that then. I had a whole folder for it. So if the courts would please allow us to come back to another day for the actual adverse possession claim, what I would like to present to the courts today, Your Honor, is something called, now I apologize for not knowing the direct legal jargon, but it's something along the lines of the poisonous fruit doctrine.
The fruit of the poisonous tree.
Fruit of the poisonous tree doctrine, Your Honor.
Now, that is a criminal process. That is a criminal principle, which basically says that if there is an illegal search, then any evidence that is obtained as a result of an illegal search would be the fruit of the poisonous tree, and as a result, it would be excluded. Normally, that has no application in a civil case, which is what we're dealing with.
I understand that normally that would not adhere to such a case. However, I've been arrested over these matters several times and have been dealt great stress and cause by the defendant, and I do not wish her any form of, I don't know what my letters wrote. I don't want her to go to jail. I don't want her to be punished. From what I understand from Ms. Wallace, she was the first lady officer here in Dover, and I respect her for that because I'm a girl dad, Your Honor. However, she lied to the sheriff on November 4th when he came over to my house. She lied again November 12th. She lied to the courts on December, somewhere about December, saying that she had rights to this property. She filed an illegal detainer warrant. She's had me locked up several times, Your Honor. And I do have all the proof on my phone. I requested that I use my phone to be able to present any form of evidence. I also have 3 copies, one for Your Honor, one for Ms. Wallace, and one for myself, which is a new motion for Exhibit XX bundle that proves everything that I'm saying today is very true.
Well, I want to make clear to you, I want to give you an opportunity to present your case, but this case arises from your claim of adverse possession and ownership by adverse possession under a state statute. And that is the issue that is controlling all of the motions that you have filed. All stem or arise from or are connected to your claim of ownership. Your complaints that you're giving today are not a part of that action. They're not a part of what we are supposed to be hearing today. Today is supposed to be solely about whether or not you can claim, you can establish a legitimate and sustainable claim of adverse possession and ownership of this particular piece of property. So I'm willing to let you put on your proof on that issue. But that issue is what everything else is arising from. All of you have a number of motions. For example, you have all these motions for a stay of immediate stay of eviction, opposition, to a motion for an order. That there are just so many motions. Your motion for relief, your first amended complaint, a motion for relief, your supplemental filing, and a motion for relief, your objections. You filed a letter to the clerk, your amended and supplemental motion for relief, and emergency motion for immediate ruling. And what I'm here today to do is, because of the numerous motions that have been filed, I'm trying to give you an opportunity to establish whether you have any standing to even litigate this issue as a claim for adverse possession and ownership.
Well, Your Honor, you wrote in your judge's order on December 1st that I do have an adverse possession claim. You stated that if you were to be the one to hear it.
A claim is not anything more than a claim. Somebody has a car wreck, they have a claim, but it's to be established whether they have the right to judgment. So you have a claim that you're making. A claim is nothing more than an assertion that you have a right. And the question of whether that claim is legitimate and whether that claim is one that should be granted is an issue that is for a final determination. I'm trying to give you an opportunity because all of the other motions you filed all stem from your claim for adverse possession. If you don't have a sustainable claim for adverse possession and ownership of the property, then you have no right to the property. You have no right to lease the property to your tenant, and therefore all of your other issues would pass because of that fact. So the first and foremost claim is for adverse possession. And are you prepared to litigate that issue today?
I have a folder that I've submitted to the judge. Ms. Wallace has seen it prior, I believe. She can correct me if I'm wrong, please, ma'am. I can try to go off memory from what that folder was. I'd be able to, because it's just the truth. My family's lived at 2138 Old Highway 79 since March 2000. Continuously. Grandparents, uncle, myself, all the way to this day. The neighbor, Miss Marvin Wilson, who said that she had no family. So our family took care of her. My grandparents passed away a year after moving in there. My uncle and father continued taking care of it. My father died. My uncle continued. When he died, I continued. That's where my claim comes. That's been for over 25 years. And in that folder, I've got pictures. I've got documentation.
Excuse me for interrupting.
Yes.
What folder are you referring to?
With all my exhibits, the one that I requested that if Miss Kim has seen.
Well, are you saying this is a folder that you produced and gave to Miss Wallace?
I've given it to the courts on December
I love you, Tim.
1st, Your Honor.
So is that then something that's contained within the court file?
Yes, sir. It should be. It was documented.
And I have in the court file, there are a number of color-coded tabs. Is that what you're referring to?
I'm referring to the bundles that are exhibits A through F, I believe, with F being all the laws that I've tried to quote, because I wasn't familiar with them as far as December 1st goes, being able to recite them. I'm not a lawyer. I'm a normal human. I'm a normal man. I'm a Stewart County man, and I got educated here, so I try to be as prepared as possible.
I have in the court file, but it was apparently filed at the time of the last hearing, there are a number of tabs. They start with full script exhibit list, lease, tax receipt, photos, keys, my affidavit, LRG Homes.
Yes.
Is that what you're referring to?
Yes, sir. LRG Homes LLC is the registered principal business at 2130 Old Highway 79. Further in showing my adverse possession of being open and hostile as the law is required. It's been over 25 years. I've contacted Mr. Ruben Wyatt, which I've tried to add for the audio files to be accepted. I've contacted our neighbors. I've used ancestry.com. I've looked at Mr. Wilson's obituary where it just said the family. I went above and beyond and done my due diligence, Your Honor, in order to find out if Miss Wilson even had family. And then I went into this court system several times, Your Honor, and requested that if there are any probate against Miss Wilson. When I originally filed, they said there was none with Miss Wilson. And then whenever I did some more research, I found out there was one for Miss Marvin Wilson Rimley. So then they added that, which changed another motion that I had to add.
Okay, so that we're clear, I'm going to give you an opportunity to present your proof. You cannot submit a written statement and rely upon that. You can't just file a bundle, as you refer to it, of exhibits. You have to make, under the rule, you're representing yourself. You have to take the stand and testify, and then you can introduce an exhibit. And if it is admissible under the rules of evidence, then that exhibit would be allowed. But there are things that you need to understand. I'm required by law to hold both you and Ms. Wallace to the same standard as if you had an attorney representing you. And because of the fact that we're dealing with the ownership of some real property that has value, I'm required to do it in a way that gives you both an opportunity to be heard, but I'm not going to open it up for you to just basically make a bunch of hearsay statements about things. You're going to have to adhere to the rules of evidence for me to make a ruling if one way or the other. So
may I request from the court, since you did admit so you should have recused yourself from the thing, may I ask that you do that and appoint a special judge?
on what basis do you have for me to recuse myself from this case?
You've already admitted to knowing Miss Wallace, and you openly stated whenever we first came in here on December 1st, you said, I know Sheriff Gray, how you doing, Miss Wallace? And then you pointed to me and said, and you are? That was very intimidating for me, sir. Your Honor, respectfully. And then when the paperwork said that the TRO had already been denied, and then I was having a hearing for my quiet title claim on December 1st, which you should have those documents, Your Honor, that it was for my actual quiet title. So I came in here with 3 folders prepared, one for Your Honor, one for the defendants, one for myself. But you said that we were only doing the ex parte TRO that day that had already been denied previously. And since that day, I had already been arrested several times. Marcus Jackson had been arrested several times. And now since December 1st, I've continued to be arrested. That's why there's so many motions there, Your Honor. I've been stonewalled by clerks. I have proof. I've been lied to by clerks. I have proof. I've been lied to by county attorneys. I have proof. And I'm prepared to present it in front of a judge that would be fair, Your Honor, respectfully, sir.
All right. Well, under Rule 10 of the rules of the Supreme Court, I'm required to make a ruling on your motion to ask that you're asking for me to recuse myself. I'm required to make a ruling on that before we take any further action. So we'll take a short recess.
All rise.
Under Rule 10 of the rules of the Tennessee Supreme Court, court is required to address any motions that's made to recuse or disqualify a judge in a case. I don't believe that I have a conflict in this case, but because of the fact that I'm familiar with Ms. Wallace and have all of the other 3 judges who preside in this court have already recused themselves because of their personal knowledge of Ms. Wallace, and I had agreed to hear this case despite the fact that I had some prior history, because I believe she would be the one who would be entitled to raise an objection to me hearing this case. But based on Mr. George's objections and the fact that he raises the issue that I'm familiar with Ms. Wallace, and he doesn't think he can get a fair hearing, I've reviewed the Canon 2 of the Rule 10 of the Rules of the Supreme Court. And out of an abundance of caution, I'm going to recuse myself from this case.
What? That worked. That worked. I was ready. I was ready for the judge to throat slam him with words. And he's just going to recuse himself? I mean, I agree with him, but I was ready for a total bloodbath. No.
Now, because I have recused myself from this case, all 4 judges are now out of this matter. What that means is that we're going to have to ask for the Supreme Court to designate a special judge. There will be no action taken in this case until such time as that special judge is. So there's nothing, in my opinion, that needs to be filed. Of course, I'm recusing myself, but I'm just telling you that the clerk's office can't do anything for you until the special judge is designated. So I know you have some issues, but I will state that our clerk's office is a professional group of people. They deal with people. My experience has been politely. You may have strong emotions and feelings about the situation, but I would urge you to deal with them professionally, and that you'll get better service from that rather than creating any sort of issue. Based on my having found that I am required to disqualify myself, I will, and based on his objection, I'm continue or adjourning this hearing until such time as a special judge is designated.
You're on.
So I don't think he would have recused himself, except for the fact the other 3 judges already recused themselves because she was the chief of police. So they all know her. So I think had this guy got Judge Wolf first, there was no recusal going to happen. None.
Can I ask one question?
Yes, ma'am.
He is continuing to collect rent, and I had filed a motion that be to the state because
Objection, Your Honor.
Be quiet, please.
Chief Carrier has a lien on the state, and he did not check it down. This is very frustrating, and it's been a nightmare for our family.
I understand
Being
that.
accused of things that are not correct, and I have hardcore documentation, wills, taxes, that some landscaping has been done and mowed by us, electric bills, water.
Mr. George does not own this property. He has a claim for ownership, and that's why, under the circumstances.
But why should he continue to collect money off something that is not his? That's my only, I would just ask that you consider putting that in a trust or an estate, and so he no longer collects money.
Well, and I think that's a legitimate request, but having recused myself from the case, that'll be up to the special judge to do so. Mr. George, I would simply comment that even though I'm out of the case, I have advised you on more than one occasion, you have a claim for ownership. You don't own the property until a judge rules that you do, and therefore, under the law, it would seem that no one has, if you just have a claim for ownership, you don't have the right to lease the property or collect monies regarding. I'm going to leave that to the special judge who's going to be designated to make that determination. But it may be a situation where Ms. Wallace is correct that those monies, you may be liable for the rent that does it, but that will be up to the special judge. I have recused myself, so this matter is adjourned.
All rise.
He's going to have to pay back all that rent if he loses. Doesn't sound like he's going to lose, but I really have no idea.
On the record in the matter of the state of Michigan versus Daniel Alston, 25-03722.
Emma Buckingham for the people. Assistant Public Defender Justice Job on behalf of Mr. Daniel Alston, who is standing to my right.
Mr. Alston is supposed to be here at 10:30 today.
Yes, I was running a little late.
A little late, because I heard you asking somebody what time it was at about 1:50.
No,
You asked the young lady in the hallway, do you know what time it is? She told you what time it was.
Oh, yeah, 1:50, but
Yeah.
at 10:30 this morning, I came here this morning, but I was here at like 10:50.
Mm.
I talked to him, and he told me that to come back at 1:30, and I was here.
At 10:50? I was sitting on this bench at 10:50.
I was here, man. This morning.
She was gone by the time I talked to you.
She was gone by the time.
And your attorney was gone too.
Yes.
That wasn't 10:50.
I could be wrong on the time. It could be
Yeah,
about 11
yeah.
o'clock. I caught the 10:45 bus because I missed the 10:22.
Oh, you caught the 10:45 bus and got here in 5 minutes upstairs.
Yeah, I'm just right at the VOA.
Right. I know you did right at the VOA, but the bus got you here. You got through security upstairs and in this building in 5 minutes.
Running.
Mm-hmm.
Running.
There was a sense of urgency around.
I
I was
see.
trying to get
I
because
see.
I've never missed a court date.
Got it. Okay, got it. I hear you. Well, nonetheless, you are here. I said I would hold it for 48 hours because your attorney was clear that you had been in contact with her, so she expected you to be here. And that she said she would give you a phone call. I see here that there is an offer. Excuse me. There's an offer for you to plead guilty to count 1, receiving concealing stolen property less than 200, and they would dismiss count 2. Is that accurate?
Yes.
Do you want to take that offer or accept it and plead guilty to count 1? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? You can put your hand down. This is an advice of rights and plea information sheet. There's 2 pages here. This lists all but the 12th right, and then there's a signature page here. Is that your signature? Would you go over these rights? Do you understand each of the rights listed here? I'm going to date this for today, okay? And you're willing to give up these rights? Each of these rights, that is, so that you can plead guilty to count 1? So that means that you understand your right to the presumption that you are innocent until proven guilty, that you can maintain your innocence, take this matter to trial, have a jury trial, require the prosecutor prove each element of each of the charges that they're bringing against you beyond a reasonable doubt before you are to be considered guilty. You understand that? You have the right to be silent at any trial. They will not be able to use that silence against you to prove that you're guilty or to imply that you're guilty. You have the right to waive your silence, take the stand and testify at your trial and present any evidence or defense that you believe support your defense in this case. You also have the right to question or cross-examine any of the witnesses that the prosecutor calls to testify against you. You understand those rights? Okay. And you want to give all of those rights up? Is anyone threatening you to get you to do that? God threatened you? Yeah, you go down.
He just told me.
He's not a man, so
if you don't do
did any
it,
man threaten you?
no.
Okay. Any promises extended to you, not by God, but any persons
No, ma'am.
that got you to be coerced to want to plead guilty to count 1?
No, ma'am.
Lastly, and very important, are you looking to plead guilty to count 1 because you believe that you're guilty of count 1?
I'm holding accountability for that. Yes.
Because you believe you're guilty? Okay. Are you on probation or on parole?
I am on parole.
Until when?
I got 10 more months.
MDOC?
Yes.
You understand that by pleading guilty, it could result in a conviction that can have impact on your parole status.
Yeah, I talked to my parole officer about that, and she's already had violated. I did 18 days in jail for it, and then I got out, and we had talked about it, so she knows all of everything that's going on.
Okay, it also could result in a conviction if you plead guilty that you might need to put on a current or future job application.
Yes, ma'am.
And it may have impact on where you can travel or get immigration status. Some people, or some countries, I should say, are not allowing individuals with crimes related to theft into their country. You understand that? Okay. As to receiving, concealing a stolen property less than 200, how do you plead? Actual basis.
Mr. Alston, on or about December 14th, around 405 South Butler Avenue, Did you buy a wallet from someone?
Yes, I did.
Did you have reason to know that that wallet was stolen?
I did.
Did that wallet carry a value of less than $200?
I carried lessons on, yes.
Did this event happen in the county of Hingham, the city of Lansing, and the state of Michigan?
Yes, I did.
I think that.
You bought a wallet. What kind of wallet was this?
It was a Coach wallet.
You bought it from just someone off the street or someone you
Yes,
knew?
it was a nice little Coach wallet. It was nice.
Okay, and was it new?
It looked new.
What do you mean it looked new?
It was very close to being new, but it didn't look new.
Well, oh, very close to this. So you thought you knew that it was used?
Yeah, that's why I paid the amount of money I
Oh.
paid for it.
Okay. And it had things inside of it?
That's where I knew that it was stolen.
Oh, okay.
When I looked inside of it, we saw the things inside. That's how.
And you still bought it?
No, I didn't realize it until after I bought it.
Or after you bought it, then you investigated it further?
Yes.
So you didn't open the wallet before you bought it? I don't even go to a store and buy a wallet without opening it. I don't.
It was so cold and I was moving so fast, and then when
But you just had to buy a wallet,
I bought
a Coach wallet.
Yeah.
Even though it's cold and you're moving so fast, because you move fast, because you got from the VOA on the bus through security up here in 5 minutes.
Close to 5 minutes. I was moving fast.
I see. Okay, any questions from the prosecution?
No, Your Honor, prosecution satisfied.
The court is satisfied with the factual basis that finding the plea voluntarily and intelligently made. The matter scheduled for sentencing is going to be March 24th at 9 a.m. When you leave here, go downstairs. You have to check in with probation so that you can get set up for a pre-sentence interview. They will advise the court about your past criminal history and a recommendation about how they believe you should be sentenced. Is there any restitution being sought?
No, Your Honor, there's not.
And there's no victim, correct?
No, there is not. The property that was found was returned.
Do you have any questions for the court?
Your Honor, is there any chance that we could wait the sentencing for later? Can we have that happen today?
You mean you want to move to immediate sentencing when he's already on parole? And no, because he moves too fast. And I think what we need to do to help him is slow him down a little bit. And maybe he can make some better decisions. So I don't have his criminal history. I don't have anything about his parole status or even what he's on parole for. And that would take me some time to deal with. And I have a meeting in 12 minutes with the state bar.
Okay, thank you for the.
So we will see him for sentencing. He is welcome to appear for sentencing from Zoom though, as long as you have a working device with a video. Okay?
So if you're new to this stream, sometimes I play the YouTube judges like you just saw. Sometimes I don't. I have a pocket, like a huge pocket book, I should say, full of my own exclusive judges that you can only see here on this channel. So make sure you subscribe if you haven't yet, or you're going to miss out on these judges. We do, all the court channels do a lot of the DUIs and the DVs and, people screaming and melting down in front of the judge and lying to the judge like that guy just did, and the judge tearing them apart. But today, we're going to go to a different kind of case. It's a divorce case, which we do sometimes. There's no screaming, there's no yelling, there's no meltdowns. It's just interesting. So, especially the one attorney, you'll see what I mean. We're going to move to him next, and I'm pretty sure, I can't remember what state I'm going to. So when I say this judge is exclusive, I might be lying. I can't remember now. Now that I said that, I might be lying. Hold on. Once I find out what state we're going to, see if anybody can recognize it. No, this is This is not exclusive. This is
Okay, response.
YouTube.
Okay, Judge, I'm going to give you a summary. First of all, these two have been married for 3 years. They've been separated for a year and a half. We're set for a final hearing in February, and we think a motion for continuance is probably going to come next, and we're definitely opposed to a continuance. This case needs to be resolved. Mr. Naylor's 215 motion is asinine. We have responded to him. We've given him 775 pages of documents. We've given him 775 pages of documents. I've got a summary of things we've given him. I have been asking him for a list of what he thinks he is missing since day one. Since we stood in the courthouse, I asked him for a list. And the response I got was, we want everything.
He wants a list, sir. Get him a list. We take a shot every time he says list. No, don't do that. We'll all be dead. Monica, thank you so much for the PayPal. I really appreciate it. Thank you.
I don't know what that means. I sent him a letter back in November, and I said, give me a list. No response. I followed up on that 2 weeks later with a letter. Give me a list. No response. I finally started sending him letters asking for these things and putting them in the court file so that you could see that we were asking him, tell us what you want. In his motion to compel, he still doesn't say what he's missing, and today he doesn't say what he's missing. I can't read minds. I'm really good at my job, but I cannot read minds. If they won't tell us what they think they're missing, we can't tell them if we have it. We can't provide it to them if we don't have a specific list. I have given him everything I have. Everything I have given him. Because I don't want to get to trial, have a document, and you say, understandably, you didn't give it to him. Everything I have for trial, I have given him. And yet to this day, he will not tell us what he wants. We have discovery to do. I sent him written discovery. He flat out ignored it. He didn't object to it. He didn't respond to it. He didn't do anything with it. That's where the sanctions ought to be. I asked him for deposition dates. I've asked him repeatedly for deposition dates, and I either get no response or I get, well, I've got a 215 motion on the table, and that ought to be heard before we do depositions. Why? Why can't I ask her what her claims of fraud are in this petition? I just get crickets from the other side. And we're a little annoyed at that at this point. So here's what I'm asking you to do. If you want to give them anything, give them an order to give me a list of what they think they're missing. And we will give them those documents if we have them. I doubt we do because we've given them everything we have. And then make them let me take her deposition. I don't care if it's on a Saturday. I don't care if it's on a Sunday. I don't care if it's 7 o'clock on a Friday night. I don't care when it is. I will work with Mr. Naylor's schedule. I will take it anytime by Zoom. I'm asking you to award $800 in attorney's fees for me having to deal with this nonsense. And I'm asking you to keep this trial set. I'm asking for 2 more things. She has 3 separate property horses that are at Mr. Blucher's place. He wants her to come get them. We're going to be at trial in a month. I don't know if she's planning on leaving them there for infinity, but she needs to come get her horses, preferably this weekend. She has things at Mr. Blucher's place. He wants her to have her things. She needs to come get them this weekend. We don't think that's too much to ask. So we're asking you to deny their motions. And at this point, you may say, look, you've had plenty of opportunity to give them a list, so I'll leave it to you what to do there. But we're asking you to order us to allow her deposition. And quite frankly, they're past the discovery deadline. They could have taken his. Now, if you want to order both of them, we're fine with that. But we think we ought to be allowed to take her deposition. And we want to try this case in February. We don't want to put this off anymore.
What date do we have this case set for trial?
It's either 18th or 19th of February.
February 18th, Your Honor.
Thank you.
And we're going to ask you not to grant a continuance because I think that's the next thing that's going to come your way. But it's not on the table today.
Well, Mr. Naylor, your client's concerned about this income that might come to her in March. So wouldn't it be in her interest to go ahead and keep the trial setting in February?
With them not being able to bring in discovery they haven't given us, Your Honor. Yes, that's exactly what my motion since October 30th has said. Please, and just so you know, and please, Your Honor, I'm very sensitive to the fact that you have many cases, and your court clerk does an admirable job of juggling all those and getting them set up. But the first thing we basically said to your clerk was, we called her up and said, when can we get a trial setting and a hearing on a motion to basically a motion to compel, motion for sanctions? That was in mid-September. When we filed the motion that day, October 30, we sent a request to your clerk saying, and then this is, please read the motion, after we've been saying to them for months, give us full disclosure, and they didn't. Because my client, one of the key issues here, Your Honor, and I'm sorry for being long-winded, but I am trying to focus on the arguments before we maybe call my witness to go through the things that haven't been produced and have never been produced. But basically, we went through all of that for months trying to get in full disclosure, which what we're going to show was very clear and didn't get until almost 2 months after we filed the October 30 motion for sanctions. Then we start getting in some more documents that go to this issue. That there's an LLC involved here.
Yeah, but there's also horses, guys. There's $95,000 on the table, and he has her horses. She has to get her horses from him, but he has them.
Now that was started during the time of the marriage. She was listed on the original documents. She put cash money investment into that LLC, and we weren't getting. And then when the divorce comes along, Mr. Blucher and his partner, other members in this LLC, all of a sudden remove her from any access to the business, cut her off the bank accounts, cut her off the credit cards, and have given us no indication of how they did that, what procedures they followed, how much money they're earning, interest, equity. None of those kind of things were coming in. My client knew that there were documents. I asked him for 2 months. Give us the documents that show about this LLC. I asked him. He says, I'll get them together. He didn't 2 times. He then says, my partner members and his wife have those documents. Okay, I call them. They don't give them to us. Then attorney gets involved. I'd say we need the documents we've requested formally. You have your client had 30 days. By the way, by the time they can't complain about any of they can't object to the discovery because they didn't make objections within 30 days because they didn't even hire a lawyer within the first 30 days after discovery was issued. Didn't get the discovery, still don't have the discovery. All of those issues, which we can go through in just a moment, item by item on what we don't have extensive. Now then they're saying, oh yeah, let's go to trial, but you don't have all that discovery, but we can put on any discovery we want. That's not the way the rules are set up to work. We don't have to tell them, hey, we're going to acknowledge what we know you don't have, what we don't know you don't have, so you can continue to hide what you don't have, what you haven't produced. The rules say you, as a party, have a duty to read very straightforward, very standard discovery requests and disclose fully. And with the court's agreement, I will call my witness and we'll run through those things that we've asked for, that this 720-page document dump. Still, first of all, we got some documents. November 20th, almost 2 months after we filed a motion to compel and for sanctions of the fundamental limited liability company information that was very instrumental. My client knew that she'd seen those records, knew she was on them, didn't get those until November 20th, and still they're just partial responses. So that's why from the get-go, ever since this potential $95,000 earnings has come up, all we've had from the other side is delay, lack of complete disclosure as mandated by the Texas Rules of Civil Procedure. and after repeatedly asked for it, filing a motion to get it, we get a partial disclosure and we still don't have it all. And yet then whenever we finally is kind of, might not be quite the word, but after we do get a final hearing that we've been asking for a couple of months from this court to be set in February, that's whenever they got very busy about now they want their discovery, even though they have not fully complied with our discovery to such an extent we've had to file a motion for sanctions seeking to exclude their right to introduce any discovery. And so, yes, it would be ludicrous for somebody to say, we're going to give you discovery with a motion pending that suggests the judge may not allow you to have it at this point because of your prior transgressions in the discovery arena. Now then, with all of that said, I would request an opportunity to call my client as a witness regarding the documents after reviewing the 720 pages that were finally delivered some 4 months after they were due, 3.5 months after they were due in November 20, still are woefully insufficient and should be considered in determining whether or not this party is engaged in either intentional hiding of the discovery ball or gross neglect in simply getting their act together in a timely fashion as mandated by law so this case could be moved forward. We wouldn't have a problem with $95,000 of potential income caught up in a delayed trial without full disclosure.
May I respond?
Yes.
I'm not sure why you need testimony. What I'm hearing is they have a list. They have a list that I've been asking for. Just give me the list. If I have them, if I can get them, I'll give them to you. If I don't have them, I'll tell you I don't have them. I can't give them to you.
Let's do snake bites. Anybody want to do snake bites? Next stream, next one.
Okay. Mr. Naylor, you want your client to go ahead and identify which documents she believes have not been produced?
Yes, Your Honor, if I might.
Okay, go ahead and let's call
Your
her.
Honor, basically, we're going to be working off of the very standard customary request for information that was submitted to the other side. Number one, Tiffany.
Let me go ahead and swear her in.
Yes.
Raise your right hand. Do you swear or affirm the testimony you will give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, before your attorney starts asking you questions, please go ahead and spell your first and last name for our court reporter.
It's TIFFANYMCLAURY.
Okay, you may proceed.
Very good. The first item that we asked for were all documents, including invoices and billing statements, evidencing the contractual relationship. Strike that, Your Honor. Let me give a little predicate for the court's benefit. Have you reviewed all of the documents produced by the respondent as they have come in? Have I gotten them to you and had you review them?
Yes.
And have you reviewed the information we requested from the other side at your direction?
Yes.
She looks like she takes care of horses, doesn't she?
Okay. Now then, subject to that information, you asked for all documents, including invoices and billing statements, evidencing the contractual relationship with attorneys, experts, and/or investigators in connection with the case.
Judge, I'm going to object to leading.
I'm just reading.
Ask what documents she's missing. Can we just get to that?
No, you're asking what documents are missing. We're going to go down the list that we gave your client 2 months before you appeared in your office, counsel, and say, did you ever get these and when? And so that's what we're trying to do.
Okay. Mr. Naylor, I do want you to cut to the chase. We're taking up a lot of time here. And if you know what's missing, I want you to go ahead and ask that question to your client and have her identify what's missing.
There are about 20 things that are missing, Your Honor.
Judge.
Okay. Well,
Judge, they're missing. So she doesn't have it. She can't tell you what it is because they're missing. But she married the man and lived with him for 1.5 years. So she knows that he had this business or this overseas account. They're not included in the stuff that they gave her. She wants the things that are missing.
Well, she can list 20 things then.
Very
Let's
good.
get on with it.
All right. Number one, were those there?
There were no invoices or
Number three, all letters and correspondence, including electronic writing that constitute or contain matters relevant to subject matter of this lawsuit. Were there any emails?
Judge, I'm going to object to leading. Again, if he's got a list, tell us what the list is.
It's the list that was served on you, counsel. I'm just reading off of the request for documents that was served
Okay.
on your client.
Judge, we're going to be
Judge, if this lawyer would just shut up and listen, he would get his information and you would get your information. However, the judge does not agree with me. The judge agrees with the annoying lawyer.
Taylor.
day at this rate.
Okay. Asking,
Yes,
we
ma'am.
need to know what specifically she knows exists that was not produced.
About 20 things, Your Honor.
Okay. Let's go through them. And if she knows there's an invoice, I need her to give me her personal knowledge of why she thinks that document exists, whether she's seen it or how she knows about it, and why we know for a fact that it is in existence and is in fact missing.
Okay, let's go to item number 5 on the request for production. We ask for all federal, state, and income reporting documents, including tax returns, etc. What is your answer to what they actually gave us?
the 2024 personal tax return for Mr. Blucker was not included, and he did receive a refund on 10/15 of 25.
Okay, moving on to request number 10. With respect to all accounting reflecting funds and mutual funds. What did your review of that request indicate had not been provided?
All of the statements from the savings account,
A and B.
A and B savings account were not provided. There was no documentation regarding his daughter Carly's account, which he opened for her and had access to. And there's no documentation of payments from Chuck and Elaine, who are boarders at his house.
How much was that in college?
They are on full board for their horse, which is $750 a month. He usually cashes these checks.
Okay. Moving on, item number 14.
I didn't, Judge, I didn't understand what that last item was. What's the item they're asking for?
Okay.
I've got 2024 tax return, personal return. I've
Mhm.
got the A and B savings account.
There was no information regarding the horse boarding income my client's aware he was earning during the marriage from Chuck and Elaine in the amount of $750 a month.
Chuck and Lane. All right.
Chuck and Elaine.
What was the last name of those folks?
I do not know their last name, Your Honor.
Okay.
All right. Moving on to item 18. All
Wait
records
just a
relating-
second. Wait just a
Yes,
second.
Your Honor.
Ma'am, I believe you testified something about his daughter's account.
Yes, ma'am. She has an account with Emerald National Bank, which Donnie opened for her and had access to. And there was no documentation for that account.
What is her name?
Carly
What is her last name?
Blucker.
Thank you. Okay, go on to your next question.
Very good. Thank you, Your Honor. Let's see, 18. We requested all records relating to safe deposit boxes maintained by you or on your behalf, including records of entry. What is your knowledge of what might not have been provided in discoveries in regard to that request?
I'm not aware of any safe deposit boxes, but there is a safe on the property. I've never seen the contents of it, and he has claimed to he's forgotten how to enter the safe. But I know he has things in there. Whether they're relevant or not, I'm not sure.
Do you know if there's any documents in there?
It's a possibility. I know there's the registration papers for a horse that we have come up missing, and they have not been where he has said that they were. So that's a possibility that they are there.
Okay, this
One of the-
registration for this horse, is it something that you've asked for in discovery?
She is involved in she's community property.
Can we have the name of the horse? I'm sure my client
Her
wants to tell me.
registered name is Third Time's a Charm.
Third
Okay.
time's a charm. I love her. I love that
Your Honor, of
horse.
course, in responding to discovery, it's incumbent upon the party responding to say, here's the documents we're giving in response to these specific questions, so that it's not just a big morass of 722 documents. Say, number 18, here's what's in the safe deposit box or not in the safe deposit box. They can answer that, but we don't have anything that denominates what this 722 pages of stuff is and isn't. Therefore, it's of no value in fully preparing for trial. Now that we would like to move on to paragraph to 20. You asked for all certificates of title and current licenses. What do you understand from reviewing the documents? Wasn't produced there.
Title or registration receipts for the truck that he owns.
Okay. 21. All policies of it. You asked for all policies of insurance, whether life, health, automobile, disability, etc. What did you find in response to that? Inquiry number 21.
There were no insurance policies of any type included.
Okay. Number 22. You asked for copies.
Wait a second. Let's back up.
Yes.
You said no insurance policies were included. I need you to identify what you expected to be there.
His
Insurance
auto policies,
policies.
Health insurance policies, life insurance policies, homeowners policy. Those are the ones that I would be aware of.
Do you have any idea about what companies were used for those? Can you identify them any further than that?
I know the auto policy is through Nikki Dole. She's a State Farm here in Amarillo. I believe she handles the homeowners as well.
It really bugs me that the judge is making her figure out what is not there. I mean, insurance policies, the judge should have, instead of saying to her, well, what are you talking about? She should have included it. We need all the insurance policies.
The health insurance is through the Veterans Program. I'm not sure the exact name of it. And I'm not sure what any life insurance policies would be under.
All right, go ahead.
Thank you, Your Honor. Item number 22 you asked for copies of originals of all credit files, loan applications, credit applications, promissory notes, guarantee agreements, etc., to which the respondent was a signatory since June 10, 2023, the date of marriage. What did you see in the records produced in response to that request for documents?
There were 2 loan advances through the A&B checking account. One was on June 10th of 2024 for $4,000. I'm not aware of what that was for. And there was another loan on September 16th of 2025 for $2,000. I'm not aware of what that was for. I just saw that on the bank statements themselves. There was not actual documentation of the loans.
What was the date of the 4,000 advance?
June 10th, 2024.
Okay.
Moving on, Your Honor. Item 25, see if there's any any credit card debt floating around out there that you might need to be aware of in resolving the divorce action. You requested all credit card statements, annual summaries, and receipts for expenditures made and indebtedness incurred by respondents since June 10, 2023. What did you see there that you believe was not full and complete?
No, there is a discount tire card and a Best Buy card. There were no statements of any sort relating to either one of those accounts.
Okay. Item number 32. For the period from June 10, 2023, please produce all your electronic data, including but not limited to any messages sent and or received through the application known as WhatsApp, and authorization for Katie Lynn McCat, pardon me, that's a misprint, Your Honor, digital artifact from another case, to access such records and devices to attempt to obtain and recover information. And let's combine that with 33, all your data not limited to messages sent or received through any social media accounts, text messages, entire contents, and authorization for Tiffany McClory to access such records. Now, I'm going to amplify a little bit on that, Your Honor. The LLC, somehow or another, these guys were running it after they basically kicked her out without any notice, or we don't believe authority, cut her off from the LLC that she invested in, that they continue to operate. And we want to know if there were communications back and forth between them. What did you find in regard to the response to that type of information we requested?
Information or access was.
I can't hear her. Neither can the court reporter.
I'm sorry. No information or access was provided for either one of those items.
So I don't understand what they're asking for. Are they wanting to dig through his phone? Are they wanting
Text
they want
messages,
to make
counsel. Text messages for one, counsel,
You want
emails,
every
text
text
messages,
message he's ever
electronics.
Okay.
Yes,
Gentlemen,
since
don't speak over each other.
inception.
Mr.
Pardon me,
Naylor.
Your Honor. Yes, I apologize.
Okay, we're not going to speak over each other.
I
Okay.
apologize.
I wouldn't expect him to produce everything on his phone either. If you want something regarding the LLC and any communications related to that, are there communications she's aware of that she thinks are missing?
They had to be communicating somehow, Your Honor, about how they're going to run, how they are and are going to run this LLC that they cut her out of, that she invested into. And we think text messages and emails may show that. And the only way to know they're not hiding them and delivering and giving us everything that might show what they did is to require them to give us the emails and text messages he's been involved with. If you want to limit it to the LLC or anything else involving business operations by respondent during the time period in question, we would certainly be willing to accept that. Anything less lets them hide things under the record.
Okay, move on.
And Judge, if you're going to do that, I'd ask for a specific name, the person that we're emailing.
I'll give you a chance to
Yes,
cross-examine.
Yes, ma'am.
Let him get through his questions.
Very good. Thank you. Then more specifically, I apologize, Your Honor, I'm getting a little choked up here. Item number 37, we ask for all records and documents reflecting directives by
there
you,
is a divorce.
namely respondent to any financial institution changing account use authorization in the last 6 months. Now, that was from the time when we issued this in July. See, we didn't even go all the way back to the initial the marriage. It was trying to get at what the LLC, how the LLC got cut off, how she got cut out of that. So we asked them about that for the last 6 months. What did you find in the records from that?
There was one document within the LLC documents in the discovery that was the 750 pages that said the other 3 members of the LLC had a meeting and voted to remove me from the business account. I was not notified. That's the only, I was aware of it through my own personal knowledge back in May, but I was never made aware of it by any other member of the LLC.
Did you get a copy of that document that they supposedly voted on and told the bank they voted on?
Not until it was in this discovery that was provided in November.
Okay. So we want that amplified on and set out specifically.
Okay, you're moving away from the microphone again, Mr. Naylor.
And I apologize for that, Your Honor. Move the paper out of the way might help. Of course, we want to have a response that says, in response to 37, here's the document and or documents that are responsive to that, no more, no less. And that way we know what's there and what's not there. Moving on to 38, something touched on previously. We asked for all records and documents reflecting income from horse boarding. Of course, this is during would have been relevant to the time of the marriage where he's getting income from it. That would have been community property. What did you find in regard to that?
It was incomplete. The bank statements showed some deposits made from Lisa Hand, who is a boarder, and Chuck and Elaine, who are the other boarders. But it was not complete. Lisa pays $250 a month. Chuck and Elaine pay $750 a month.
Okay. Moving on to 39, Your Honor. We ask for all payments or settlements from or as a result of prior employment by Pantex. What did you find in regard to that request?
The statements that were provided for this account were incomplete. I know the first 4 or 5 months of 2024 are not provided. That was after he had received his first lump sum from the Pantex. And then
Here.
yeah. They're incomplete to where it doesn't show any other payments from Pantex, which I know there have been a couple others.
Moving on to 41, all documents reflecting any apartment ownership or leasing.
None of that information was provided.
Now, Your Honor, if they got it, they were under duty to tell us in their response. We have no documents responsive to this request. But so again, here we are, less than a month out from trial now, and we still don't have tied down information. Moving on, all documents for 42 requested all documents reflecting a horse sale in February or March 2025.
This horse was sold. I know the owner picked this horse up on February 22nd. I was told by Ms. Plucker that I would get $3,500 and the remaining $1,500 would be used to pay the lady who comes and feeds while we were gone. He would just use that remaining $1,500 to pay her as she had to work. There was no documentation of any sort regarding that.
And item number 44, all documents related to ownership, control, or sale of a skid steer.
The skid steer is used by the company. It's Mr. Blucker's personal skid steer, and the payments are made out of the personal account, but it has been used for Agent Construction Services businesses, which that payment, I'm assuming, goes into the business account.
So is it safe to say that basically without those type of documents, you cannot track what's going into and coming out of the LLC that you invested into during the time of the marital relationship?
Yes, sir.
Just
Your Honor,
specifically what document we're talking about?
any document related to the ownership, control, or sale of a skid steer. Basically, if he's getting money in on it, let's see the money coming in. If he's spending money on that thing out from somewhere, let's see where he's spending his money from and going to. Is it coming out of community funds, separate funds, LLC funds? Those are the kinds of things that are covered by that broad request for all documents related to ownership, control, or sale of the skid steer.
That it?
Pass the witness, Your Honor.
Okay. Go ahead, Mr. Abbott.
In your petition, you alleged fraud. Tell us what fraud you're alleging.
When Mr. Blucker and I met, he indicated to me that he had been divorced for 3 years. Their divorce was not final for 4 months after we were dating. And I was not aware of that until after he and I were already married, when we were filling out insurance papers.
That it? If so,
Yes,
I
sir.
have the
That's-
deposition. I have the answer to my question now. Judge, if you'll give me a specific list of documents and when you want us to have them to them, I will either provide them with the document or a sworn statement that we don't have documents to that effect. But see, this is what I've been asking for, a list. and it takes a hearing with you to get a list from them.
Your Honor, we have been requesting those documents since July, and we finally got something resembling a semblance of those 6 weeks after we filed a motion that's saying you should not be able to have any discovery because you have intentionally or with gross negligence failed to comply with the 30-day requirement, so this case can't move forward. And here we are within 30 days of trial with them saying, now then they'll give us the list and specifically identify it that they should have given us 5 months ago. It's not our obligation to make that list and to get all that information together and to know it and review the documents. It's theirs.
It actually is their obligation, Judge.
No, it's not our obligation to list your documents and say, here's what we've got that's responsive to this request. We've gone through 44 items.
You want to, Judge, and I'm not going to address Mr. Naylor directly. I'm going to address the court as I'm supposed to. If they want documents, it is incumbent on them to give specific documents and not these broad blanket, just give us everything type things.
But how are they supposed to do that? Exactly. How? How can you tell someone what is not here? She can tell you the insurance records are not here. She cannot tell you what insurance records are not there because the records are not there. She is telling you what you are not giving her. She can't tell you exactly what you are not giving her because you haven't given it to her. This just frustrated me. Guys, I have a huge favor to ask. There are 28 people watching right now. If possible, could you please just type in chat real quick how you clicked into this live stream? Did you click from Discord? Was it a notification on your phone? Did you see my stream on your home screen? How did you get, or were you just sitting on my channel all day refreshing? Can you just type into chat really quick? It'll just take you 1 second. Maria, what is he saying? Hello?
Your Honor,
This
if
is
they
what I've
had a
been doing.
problem with the broad nature of it, they had 30 days to make an objection to it, and they didn't. And now here he is arguing an objection that's been gone for 4 months.
Tell us what you want us to do, Judge,
Okay.
and we will do it.
Do you have any questions that you want to ask of the witness in order to clarify which document she was identified?
Judge, I want you to tell me what documents these are and what you want us to do with them. Like the vote on the LLC. I don't know if there's documents to that effect. The WhatsApp. I don't even know where to begin with that. And I don't know if my paralegal wants to confer with me about some of these documents or not.
I can confer with Mr. Blucker because I believe we discussed that some of these he does not have. That's why they were
Ms. Wheeler,
provided.
you haven't been asked a question by the court.
I understand. Ashley, yeah.
Okay. Okay, let's go down through this list. I really don't think it should be up to the court to make a list. I tried to make notes while the witness was talking about what I thought she was identifying as missing. Let's go through it together and see that we can all get on the same page. I don't think anybody wants to put off this trial setting. I don't think it's in anybody's interest to do so. So we've got to make a plan about how we can get as much information as possible before then. Okay. So the first question that I heard you identify was number 25. And she identified that she was missing any records regarding the Discount Tire or Best Buy credit accounts. I think that one's pretty straightforward. Number 32, there was a specific time period there, and what she's really after is any communications regarding the running of the LLC between the other members. Is that correct?
Yes, and I might amplify on that a little bit, Your Honor. And maybe I skipped over it. I don't, things come and go in these hearings. Item number 3, we requested all letters and correspondence that constitute or contain matters relevant to the subject matter of this lawsuit. And part part of what our problem here is this LLC's been operating throughout the whole marriage, and we have no real idea about who their customers are, what kind of contracts they have with them, how long they're ongoing, how much they're getting paid, how much their expenses are, and all those documents should have just been provided from the get-go. So we would certainly, as part of two or three of those coming together, we would ask that all of the information about the LLC tell us this is what we've got, this is what we don't have any responsive documents for, point blank in response to the request that we've asked out there, that we've got out there.
Mr. Naylor, when you say number 3, what do you mean?
Well, all letters and correspondence, including electronic writings that constitute or contain matters relevant to the subject matters of the lawsuit. The LLC's included, and therefore we want to, if we're going to have a list made, we want to piggyback that very global standard request in one that says, give us all your documents that show what's going on with this LLC, how it's doing business, who it's doing business with, payments in, payments out, expenses in, expenses out. And if the answer is we don't have it, or just these 3 or 4 little documents are all we have, tell us that in response to what they actually have by way of documents.
Okay, Mr. Naylor, did you ask your client anything about that? Did she identify anything that she's aware of that's missing?
Well, you know, we know they run a business, and so we know there should be business records, but they need to tell us what they have and they don't have, Your Honor. And if they say, hey, we run a sloppy business here, we don't have any business records of that kind, put it in writing in response to our request for those, the specific request for those kind of documents, and tell us we don't have them.
Okay, so number 3 is going to be any documents that haven't been previously turned over regarding the running of the LLC.
That'd be great, Your Honor.
Okay, the next thing I heard you ask about was number 33, 32 and 33, you kind of talked about together. Those both go into the running of the business. So number 3 would include any electronic communication discussing the business.
Yes.
Okay.
If I understand the court correctly.
Number 37, any documents that haven't already previously been turned over regarding how
Hi, Beth.
the petitioner
Hi.
was removed from accessing
Hi, Dinah.
the LLC
Hi,
bank
Dinah
account?
B.
Yes, Your Honor.
Okay. Number 38 was any documentation regarding income received from Borders, specifically Chuckany Lane. And I have Luca Hurd. Is that right?
Lisa
Lisa.
Hand.
Lace a hand. Oh, my handwriting's terrible. Thank you.
Well, no, for the court reporter, Your Honor, Leisa, I believe is the spelling that will be best.
Okay, thank you. Okay, next one is any documentation regarding income received from his prior employment with Pantech. I believe the petitioner said she knows of other income. Can you further identify what other income you're aware of, ma'am?
Regarding the payments from Pantex, there was an initial one of 90,000, which was reflected in a bank statement. And then I know he received another one later that year. There's not any specific documentation as to whether there have been any additional payments made.
Okay, so later in 2024?
I'm not sure if it was 2024 or 2025. But I do know he's received another one, possibly more, as there was no specific documentation regarding those payments from them.
Okay. Can you tell me what knowledge you have that there have been other payments?
It's in the bank statements is the only, like, as I said, the original one was 90,000 in January of 2024. And I believe there was another one. It may have been October of 2024, later in the year. After that, I'm not sure if there have been any additional payments from them.
Okay. Let me try to make it as clear as possible. How do you know there was one in October of 2024?
Specifically from the bank statements reflecting that.
Okay. Other than the bank statement reflecting that, what other documentation are you hoping to get?
To see if there were any other payments other than those two that I know about specifically.
Okay. Are you looking for pay stubs, 1099s? What are you looking for?
Just,
return?
yes, Doc.
I'm sorry. What did you say, Mr. Abbott?
Tax return. W-2.
Are those the kind of things you're looking for?
Yes, ma'am. Just any documentation that shows that those payments came specifically from that Pantex.
And I believe you've already identified, or you did identify somewhere else in your testimony that there was a missing tax return, right?
Yes, ma'am.
Okay.
And it was the 2024 tax returns, what I heard earlier.
I believe that's correct. So that needs to be on the list as well. That 2024 tax return, number 10 was the savings accounts.
Okay, but what about the horse? Oops, oh no. Can you get to the
Documentation
horse,
regarding the AB
please?
savings account, the daughter's Amarillo National Bank account. Any documentation regarding, again, Chuck and Elaine and their boarding of their horses. Number 18, any documentation in the safe. Specifically looking for registration information for the horse, 3 times a charm. Number 20 was a certificate of title. The truck registration was missing. Number 21, insurance policies from State Farm or others regarding the auto policy, the homeowners, life insurance, his health, possibly through veterans. 22, loan documentation, specifically missing loan documentation regarding advances in the amounts of 4,000 and 2,000. That's June 10th, 2024 was the 4,000 and September 16th was the 2,000. And then I think we went through 25, 32, 33, 37, 38. And the Pantech, and we're down to number 40, which I believe had to do with apartment leasing. Is that correct?
Yes.
Okay. Can the petitioner tell me, why do you believe there are documents missing regarding the apartment leasing? Tell me that again.
I was made aware that there was an apartment lease in his name And I just want to know if that lease is still there or not.
Do you know where it was? What apartment complex?
No, ma'am, not specifically. I know it was here in Amarillo. I don't remember the name of the apartment complex.
Do you know what time frame?
It had it from I believe 2018 through April of 2024, I believe.
So we're talking about a prior lease agreement?
When were the parties married? Someone remind me.
They were
January
married
10, 2023, pardon me, June, I meant to say June
Mhm.
10, 2023, Your Honor.
Okay,
And
so
and they separated in October of 24.
okay, so any documents that have to do with an apartment lease during the period of the marriage, so it would be beginning when they were married through today. That would be responsive. Okay.
Right.
The skid steer, any documentation regarding income received or paid regarding this, paid by the business, received by the husband, I'm guessing, regarding his personal skid steer. Any receipts, bank deposits, anything to do with that. And then there's a horse sale, any horse sale information specifically including a horse that was picked up on February 26, 2025.
Very well, Your Honor.
Okay, so we're gonna see if we can't keep this court date. Let me look at my schedule and see if we can set up some dates. Okay. Well, it's Tuesday. Let's have all those documents in that list. Either you identify that you don't have them or you produce them by 5 o'clock on Friday, the 23rd. So that's this Friday.
Okay.
Okay.
And can you give them a deadline to answer our discovery?
Okay. I do think that you're entitled to your discovery. We are getting close to the court date. So let's see.
I would assume they've already been working on it.
I'm going to give you until Friday the 30th at 5 p.m. to get him all his discovery. Okay. Now, is there any reason we can't get the horses, the 4 separate property horses picked up this weekend? Is there any objection to getting that done?
3. There's 3 separate property
3?
horses.
Okay.
And she has things at his house. He would like her to pick them up.
Okay. Do we need to go off the record and give you a moment to speak with your client about whether she can get that done, Mr. Naylor?
Want to talk, or can you tell them what you think you can do? Happy to do it either way.
Yeah, let's talk about it.
Okay.
Mr. Blucher says she can come out at any point she wants. He just would like it done sooner rather than later.
Okay.
On February 5th.
Okay. Give me just a moment. Gloria, can you confirm that we're live streaming again?
Thanks, Dan.
They just restarted this, I
It is
think,
loaded, Judge.
all over again.
It's still loading. Okay. Give us just a minute so we can
Oh, no,
get
it's
back
not.
on the record.
No, it's not. We still have more.
Sure.
It is on now, Judge.
Okay, great. Okay, let's go back on the record in Cottle County cause 4673. We took a brief recess and we're now back. Mr. Naylor, tell us again when your client wanted to pick up the horses.
Yes, they can get started on that February 5th, 8 a.m. This weekend, just as everybody probably knows, weather seems to be inclement. Propose not to be trying to get horses and trailers and property this weekend. So we would propose February 5th, 8 a.m. project started on that, Your Honor.
Okay. When
We'd
you
be
say,
fine with that, Judge.
when you say started, do you anticipate it being finished the same day?
It should be, as you know, with horses, there's always something that might come up. But yes, if I can get it done that day, I will absolutely get it done.
Yes,
that
get
day.
your horses.
Okay, so was that the only issue we needed to take up in terms of modifying the temporary orders, gentlemen? That was it?
And her items are there also. And so I assume she's going to pick up her horses and her items.
Yes.
Is there any need for clarification about how much stuff she's picking up? You both know what we're
I
talking
don't
about?
believe so, Your Honor.
Okay, very good.
I think the parties will agree what's to go is to go. I think there is when make a list and come back to
Okay.
the judge.
We can take it up at trial. I'm sure if something does not go as, we hope it
Yeah.
goes smoothly.
Your Honor, just in finishing up my motion, we requested attorney's fees. The other side's requested attorney's fees. Our attorney's fees are responding to this 6-month now delay in getting an order that says these are the things that haven't been provided and set out. I would state the reasonable necessary attorney's fees are in the amount of $2,500.
Judge, we've been asking for a list. Today's the day we get the list. So I'd ask you just to deny everybody's attorney's fees and we'll be off and running.
Well,
Oh, hell
Okay.
no. You've had this list for months and months and months. They didn't give you a new list, sir. They didn't give you a new list today. They went through the list that they gave you months ago. What are you talking about? This attorney got me from get-go.
yeah, I feel like I'm going to have a more full understanding of this dispute when I hear all the evidence at trial. So I'm going to reserve making any ruling on attorney's fees for both of these motions until we have our trial. And when we get into it, I think it'll clarify if one of the parties is having trouble presenting their case because of it, or if there's something obviously uncovered missing. I think that might come out at trial. So I'm going to go ahead and reserve ruling on all that until we get to trial. Of course, I am going to reserve my right to exclude evidence if it is clear at trial that something has been wrongfully withheld during the discovery process. I think you all understand that.
Yes.
Okay. Anything else that you'd like for me to clarify today?
But otherwise, you're going to deny their 215 motion, I assume.
Well, I'm not going to restrict your ability to put on evidence at trial unless it is shown at trial that there was something specific that was withheld. I won't let that document get in, obviously. But in terms of the request that you not be allowed to put on any evidence on an issue, I am denying that.
So for clarity, we're off and running, working on our items.
Mm-hmm.
We want that done by 5 p.m. next Tuesday. That's the 23rd of January. And their responses to us are due by Friday, January 30th at 5 p.m.
No, I think that was a misunderstanding. I want your responses due by, let me make sure I'm looking at the same calendar. The 23rd is this Friday.
Oh, I'm sorry. I don't know why I wrote Tuesday. I apologize. I'm glad I clarified that.
Well, it's a
'Cause
couple
I'm
days
not looking at
ago.
my calendar. This Friday, 5 p.m., that's January 23rd. We'll have ours done. They'll have theirs done by January 30th, 5 p.m. that Friday. She will pick up her horses and her items at 8 a.m. on February 5th. You're denying their 215 motion. You're reserving, obviously, the right to include and exclude documents at trial. I have a list of things we're off and running on. And is that it?
Well, I don't think we clarified whether there's going to be a deposition.
I don't need a deposition now.
Okay.
I asked her the one question I had and she answered it.
Very good. Like to hear issues being taken off the table. That helps the court. Okay. All right, gentlemen. So hopefully you can get this resolved. Has anybody made any motion for mediation in this case? Does anyone think it would be helpful?
I think it'd be helpful if we can do it by
Not if that damn lawyer shows up, it wouldn't be helpful. Nothing involving that lawyer will help this case move forward at all.
February 18th.
Your Honor, I like being very frank on that kind of question. from the get-go on this case, we've said to the other side, if we can get in all the cards, know what we're working with, looks like we ought to be able to get this case settled. And when we get in all these cards, finally, maybe we'll have the information that allows us to get it mediated and settled. So yes, mediation is something that could very well be helpful. If we do that, I guess what I think I'm hearing from the other side as well is maybe we can do that by agreement if it's to be done before the 18th, February the 18th, because certainly it's not our desire to have either side put off the case from the 18th, beyond the 18th, for mediation purposes. Nobody's going to come in and move for mediation at the last minute.
Judge, I want her to go rope or whatever she does. I want her to win a lot of money. I want to wish her success. I want to be divorced on February 18th. We're off and we'll go get our stuff done, Judge.
Okay, do you have a mediator that you gentlemen like to work with?
Judge,
Of course he does.
we like to use Mike Sharpie up here. I know you don't know him. There's several mediators. Nobody's as good as Mike Sharpie. Nobody's as good at getting things resolved. If Mr. Naylor wants me to check with Sharpie and see if he's available between here and there, I'll be glad to. I've got someone that's all they do.
With this type of compressed time schedule, I'm in the process of scheduling another mediation in another case in virtually the same time period, Your Honor, and lots of mediators are already booked up. But so I would suggest to opposing counsel here before the court that let's try to work that out counsel to counsel. If we can find who we can find that has an available date that's mutually agreeable. If we were,
I want you to work on trying to get this mediated. I think we're going to spend a long time in court with me trying to understand the finances of these parties. And obviously your clients know it better than I do. So yes. I want you to mediate this case. I want you to both confer. I want you to both of you check with mediators and try to.
They did send him a list. They just read it off. They read from the list they sent him months and months and months and months ago. Insurance information. What do you mean insurance information? What insurance? Well, we all have insurance. If I had to provide my ex-husband my insurance information, it would be my life insurance, my car insurance, my apartment. You know what? He has a couple businesses. He decided just not to submit any paperwork for because she didn't specifically ask for each piece of paper. Like if I owned a business and I was going through a divorce, you would think that I would have my business paperwork ready for the judge. That was on the list. She wanted that LLC's paperwork. She wrote that blah, blah, blah LLC on the list. And they're like, what list? You didn't tell me you wanted that. What? They just read from the frickin' list during this whole hearing. They were reading from the list. Drive me crazy.
Get a date worked out by the end of the week.
Tortilla soup.
I understand if you want to try to mediate after discovery on the 30th.
Oh, I have a list. All right. I have a list. Do you guys have a list ready? In case you ever meet like a serial killer, you can just accidentally drop your list. Go get them.
But that just gives you 2 weeks at the beginning of February to try to get availability. So try to find somebody that has a half day availability in the first 2 weeks of February. Call around. You can call around to the one you want, and you can call around to ones you want and try to exchange dates. But I want you to make a good faith effort to get that done.
And not to belabor the point, Your Honor, but did I hear you say you wanted to hear something back from us attorneys by the end of this week?
Well, I want you to communicate with each other by the end of the week about available dates and try to get it set. Start that process of trying to get it set for mediation because I think that'd be very important.
Richard,
very good, Your Honor.
He either has my cell phone number or he can call the office and get my cell phone.
I just made a list of how you all logged in. It didn't answer much questions. See, we didn't get a lot of views again for this stream. And the reason we didn't get a lot of views again for this stream is because of YouTube notifications. So I did not stream this morning because I wanted to keep all of my notifications so that when I went live tonight, my YouTube notifications would go out and hopefully people would click into the stream from my YouTube notifications. They didn't. They did not click from the YouTube notifications, even though most of you said that you did. All right. Most of you said that you did. I got 1, 2, 3, 4, 5, 6, 7, 8, 9. 8. I have 8 that came here from YouTube notifications. 2 from Discord notifications. 1 that was on my channel, and 1 from their homepage, and 1 from the subscriber tab. So apparently, I mean, to me, that sounds like a lot of people clicked from the YouTube notifications to me. But I was fighting with YouTube this whole stream. You saw me typing, fighting with them, asking, why the heck am I not getting any impressions for this stream? And then they said it's because your YouTube notifications. Not enough people are clicking and chatting right away from your YouTube notifications. And I said, well, bullshit, I can see them chatting. I can see them. They just told me they clicked here from their YouTube notifications, and I see the chats right there. But thanks, Josh. It's your fault. It's your fault. Guys, thank you so much for coming tonight. I really appreciate it. I really do. I hope she gets her horse soon, because I'm not going to be able to sleep until I know that horsey is okay. But she did not want to get it before the storm. So I don't know what state we're in. I'm trying to gather what I can from the stream. I don't know what state. I really think they're in Texas. I'm going with 100% sure we're in Texas right now. And I think if that says 50th district, Judge, if that says 50 or 51, I can't read it from my monitor. That is 100% Texas. I just can't read what it says. So it wasn't really, from what I heard, it wasn't really that bad in Texas, right? You guys got some rain. The rain froze, but now it's like going to melt, right? You'll be okay. Yeah, Texas. So the horsies should be okay, right? In Texas, they're in the middle of the storm right now, but they're okay, right? If you were a horse and you were in Texas right now, are you okay or are you not okay? Are horsies freezing right now? I'm sure they're not, right? I'm sure that the barns are heated. Are the barns heated in Texas? I don't even think our barns here in Pennsylvania are heated, and we have a lot of cows. They're fine in the snow, though. I shoveled today in 15. Okay, it was a little colder. It's 15 now. No coat. but this is why. Because I had to shovel. I had to shovel. And my hand is already messed up. So I needed as much mobility as possible. And just me shoveling was, work. So you don't feel the wind when it hits you. What about their feet? Do they freeze? I think someone said this is Amarillo, Texas. So, if it's Amarillo, Texas, are the horses okay? Is Amarillo in the north? You brought it in north, south, east, and west, Kelly. Now you got to answer. Is Amarillo towards the Walmart or Pizza Hut? Anthony did shovel. Tiffany shoveled. So here's what we did. We got like 18 inches. So that's not a one-person job. So I went out first, of course. I had to start. I went out and I shoveled my porch and then down the one side of my driveway. And then I get to the end of the driveway and I start clearing out a spot, which was so stupid because I lived in Pennsylvania for many years, over 5 decades. So I know better than to do what I just did. And I did it anyway, which was stupid. So as soon as I got done shoveling that spot down there, the plow came. And the plow, I don't know what he did. I should have filmed it. I should have taken a picture because you guys are going to think I'm lying. And I'm not. I swear to God, I'm not lying. The plow usually drives down the street. Got it? Okay, that's not what he did. He drove down the street on the one side, across the street. Then when he got to my side, he drove down and he pushed a whole bunch of snow. Then he stopped at my driveway, backed up, grabbed some more snow, stopped, backed up, and went around it. And he left like 3 feet of snow just behind my car at my driveway. Now, we're used to plows just plowing in what we just shoveled. We're completely used to that. I mean, that's just, you just deal with it every single time. But what we're not used to is a plow piling all the snow up at the end of one person's driveway, especially when I'm out there. Like I missed him going that way. I missed him when I was walking out. He was doing his last little push towards my driveway. Then I saw him look at me and drive away, and I'm wondering, what did I do to him? I didn't do anything wrong to that. Listen, when there is an ice truck on the road and a plow, I do not pass them because you're not supposed to. You're not a salt truck, I mean. You're not supposed to pass them. You're supposed to let them do their freaking job. And you passing them is not going to get you home any freaking faster. Leave them alone. Let them do their job. Just drive behind them. It's not a big deal. It'll take you, what? 4 more minutes tops to get home. Big deal. Stay behind them. Let them salt. Let them plow. Don't try to pass them. It's stupid. Well, maybe T, but I wasn't supposed to stream this morning. I was supposed to save my freaking notifications for this live stream tonight, and it didn't work. But it's okay. We're going to keep working on it. We are. We're going to keep doing Wednesday night. We're going to keep doing Sunday night. No Sunday morning. We're just going to figure it out. I'm going to keep working on my stupid thumbnails and titles. They're stupid. I have to start clickbaiting and using AI because people don't click normal stuff anymore. They have to, judge loses it, judge snaps, total court meltdown. And I have to have this AI face screaming. I'm going to have to do it because I won't get any clicks if I don't do that. You know what I mean? So my titles and thumbs are about to get stupid, but I'm just trying to work here. I appreciate you guys for working with me. You guys work with me no matter what. I mean, seriously, this stream, it should have been dead years ago, right? But you guys come every day. Nobody else does, but you guys do. So I appreciate you sticking with me. It's awesome. I bet you if maybe even half of you stopped coming, it just wouldn't be worth it anymore to stream. But you guys come every day, and it's the best part of my day. No, I can't. I got to start streaming in like 6 hours, Josh. I'm not even joking. I think I have a live stream in like 6 hours, and I don't have any content because you want to know why? I love you guys more. You guys, I think about you all. All I do all day is try to find content for you. Literally all I do with my whole life right now. Because I love you. But I did find out, I had a long time off since my last stream. My last stream was like a long time ago. It wasn't this morning. It wasn't yesterday morning. It was the night morning before. First thing I did once my power went out and I knew I couldn't do anything, was I put my little headlamp on. I got a little headlamp, like pretend like a miner would use if they're going to go mining. Or I guess maybe joggers would use it, but I promise you I never used it for jogging. I promise. And I never will. I put my little headlamp on. I lit my candles. I grabbed my power bank. This is a trick, a technique, guys. So you would think so I have a master's degree in computer security. So I'm good with technical things. I just am. So you would think with me, I would have one of those sleek, lovely battery packs that you hook your cell phone and laptops up to. Listen, if you're going to buy a battery that you can, hook your phone up to later when you're out of power or something, do not go to the tech department. Do not go to where they sell computers and computer accessories and cell phones. Do not go there. Go to the camping gear. Do it. Get one of those big bricks that are like $20, but they're 20,000 mAh. That is beautiful. That is so much better than one of those thin, fancy batteries you get, external batteries, or you can get for your phone from the computer parts section that charge you 50, 60, 70, $80. That's ridiculous. Why would someone pay $80 for a freaking battery? Go to the camping session. And then while you're there, do yourself a favor. Coleman has been dropping the prices on their freaking coolers, for beer, for a while now. And you can get a really nice cooler right now for less than $30. Seriously, get a battery, get a cooler, put some beer in it, take your battery, go far away from somewhere. You have a battery. You can still play on your phone and drink your beer. It just sounds like a whole plan, Yeah, see? Josh knows he didn't go and buy the pink, sparkly, battery that's in the text session. He got that brick, that big black brick that holds all the juice. I mean, I can sit forever on that brick and I won't run out. And I don't even know why I bought it, because I live in Pennsylvania. Chances of 18 inches actually taking our power out is slim and none. Most of our power lines are underground. So now, that being said, I was out of power because someone ran into a pole. I know, because it was the weirdest thing. I went out once our power went down because I didn't want to be in the house anymore. And there was only 4 houses on my block that did not have power. Maybe 6. Okay, 5. I'm just going to go with 5 because what do you guys care? You weren't here. The rest of them had power. And then there was a couple houses over in the next block and a couple houses over that way. And then there was a strip mall. There's like a strip mall at the end of my street, all the way to the right. And like CVS was out. But Giant Grocery Store was not out. I mean, there was just pieces of the whole little spot I was in. There was like sporadically people out of electricity and people who had electricity. And of course, I was one of the unlucky ones. And you can use them for Cokes too. Is that what you said, Cokes? I don't know what that means. I missed the first part, Kelly. So, yeah. So then I fell asleep for 16 hours. Yeah, I just keep it charged. I definitely keep it charged. I don't know how long it takes to keep charged because I take it with me. So if I'm like working or something and I need juice, I have nothing in my purse, nothing. So there's like 3 things in my purse: my wallet, don't worry about, and my brick. I have plenty of room. Oh, instead of beer, shut your mouth. How dare you? Instead of beer, look, I don't go to Texas and swear at you. I mean, I did swear when I was in Texas. When I went to see Judge Fleischer, I did swear because God, it was so hot. I could not handle it. I got off the plane and instantly I was like crushed and dying and dripping, and I was so hot. And everybody's just, walking around like nothing. And I'm like, how the hell are you guys breathing right now? Where's the oxygen? And I just wanted anybody in the world to throw an ice cube at me. Just one ice cube would have just changed me completely in Texas. But no, there was no ice cube. And then they're like, hey guys, don't worry if you're hot. Once you get into the buildings to watch court with Judge Fleischer, it'll be cold because the air conditioning's on. Not cold. Hot. It was a lesser of hot, but it was still unbearably hot. The whole time. It was unbearable for me. I could not. If I go to Houston again, I'm going to bring like a you know how they have those wraparound fans? Not good enough. I'm going to need like a wraparound air conditioner because I'm going to need some ice cold air. It's so hot. There's nothing in Texas that could freeze my ass off, Kelly. Nothing. Absolutely. I bet if I went into the walk-in at the restaurant I went to, I would be hot. It is 15 degrees outside right now. And if I went to go shovel again, which I'm thinking of, I will not wear a coat. I'm just going to go and shovel. And it's going to feel amazing. And it's going to like rejuvenate you. Like the cold weather like wakes you up. The heat, man, oh my gosh, it just pressed on me and it made me sleepy and gave me no will to live. No. There was just one time, oh man, there was one part of Texas I just really enjoyed. This was the second time I went to see Judge Fleischer, right? And I'm by myself alone in a hotel room. And I walk from the hotel room to the courthouse completely alone. Wow, guys, it was so hot, but I was walking with Donald and everybody, and they were all walking. Everybody has bigger legs than me. Everybody in the world has bigger legs than me. Corgis have longer legs than me. So when you guys walk normally, I have to run. So I'm like hotter than hell, and I'm like running to keep up with everybody the whole time I'm in Texas. However, when I spent the night there in the hotel alone, and I woke up, and I walked to the courthouse myself, I got to walk at a leisurely rate that matched how hot it was outside, which was really freaking slow. And I'm just strolling along terribly slow. People are passing me, and I don't care. I'm hot. But it was gorgeous. I stopped every few feet to take a picture of something and look at something, and then I took a few more leisurely, slow steps towards the courthouse. It probably took me forever to get to the courthouse. If you guys, yes, I stayed at the Sam Houston. That's where I stayed. It was fine. There's nothing wrong with it. It wasn't great. It wasn't bad. But if I ever go to Houston again, I just want to be alone because you guys go way too. Everybody walks. People from Pennsylvania, from Michigan, from North Carolina, they all walk too fast for me. I just want to go. I just need to go slow because it's too hot. It's too hot to walk fast. If I could have had my roller skates on, that would have been a little better. I'm gonna bring my own ice maker, my portable ice maker, my battery, my brick battery. Do you think Judge Fleischer would let me take an ice maker into his court? Judge, please. It's too hot. Please. I just need an ice cube. Please, Judge. Please. You're not picking me up. I'll give you a piggyback ride. You can rest your beer on my head. That will keep it cool. Maria, me and you could walk together. And we could stop every 3 steps and take a picture of something and say, oh, look at that stone I saw in look at this patch of grass I saw in Texas. Isn't it great? I bet I still have the pictures I stopped and took on my phone somewhere. Maybe I should look at them. I take pictures and never look at them. They're all on my phone. But no, I wouldn't mind going to Houston again. I wouldn't mind going to see Judge Fleischer's court again. But, I mean, I don't want to make it a big deal. I just want to go and watch court. But it's always such a big deal. And then the judge and all his staff go out to dinner with us afterwards, and which is freaking amazing. But I feel so guilty because these people have just stopped their entire lives because I came to watch their court, and I feel so bad. I got to sit beside Judge Juanita, though, last time at lunch, and I was a total fangirler. I was fangirling the entire time. Like we walked to the table, and there's like 20 people there, a whole bunch of people there, right? I was one of the last people to get to the table because I probably walked way too slow. They were all there before me, right? So I walked to the table, and the person I'm with sits or goes to sit down, and then I touch my seat and I look over, and that was it. I was like, oh my God. They put me right beside Judge Juanita. And I started fangirling right away. I was like, oh my gosh, Judge Juanita. And she was like a little startled. I'm like, I love you. I love watching you. And then she's like, well then why don't you show my court? I'm like, because your microphone sucks. So me and her talked the entire lunch. We still text each other. We still do. I love her. I just am head over heels in love with that judge. But yeah, I just feel so bad. Like they all why would she come to the lunch? You know what I mean? Like the whole staff stops what they're doing. And I feel like I would want to go with like glasses and like a hat on, but I would die if I had to wear a hat in Texas. I just should shave my head instead. I just want to shave my head so that they cannot recognize me. Maybe I'll turn into a man. I'll wear a suit and a tie, and I'll put a little mustache on. And bind everything up real tight. And maybe I can pretend to be Kevin. Can I get a witness? I wonder if they'll tase me. Yeah, I fangirl over judges. I do. She's just so good. She's just so snarky and so good. Her judgments are solid. I love watching her. I've recorded a couple of hers recently, but I can't play them for you guys because, God, her microphone is so bad, and I already get enough trouble with courtroom audio with you people. I can't do it on purpose. Today, I took every single one of these clips and I re-edited them completely and boosted the volume up the entire way. So I sat and watched the clip, and then I figured out, I guess I'll play this one. Then I recorded the clip, so I had to sit through it again. And then I had to pop it in, and I had to edit the sound so that it was as high as I could make it go without being annoying. And then I was able to play it for you guys for like the 8th time. But I'm sick and when I listen to the YouTube videos, the volume is fine. So then I record it and then I play it during my live stream, and then nobody can hear shit. So now I'm putting everything through an editor and making the sound as high as possible now. And now I'm going to start getting different comments on, your microphone's too soft. And I'm going to quit. I'm going to quit I'm just kidding. I won't quit. What else would I do with my day if I didn't get court videos all day? Sleep? We got a stream in 6 hours. Nobody has to be there. You guys have done enough. And I appreciate it so much. I wish I could show you how much I appreciate you guys. I just don't know how. I guess I could probably try to get better content. That would show you. That's the best thing I can do, is try to get better content. When I was watching the horse thing, that lawyer bugged the crap out of me, and I was so worried about the horses that this got me. But when I'm watching it with you guys, it was not as good as I remember when I watched it by myself. So I'll do better. I will work harder. Okay? Promise. Watch your mouth, Josh. Watch your mouth. I know what you said, but that looks bad. All right. Yeah, we got to go get some sleep before our stream tomorrow. Not me. I'm gonna get good content. I'm going to. I have one. I have a great Judge Hammond. You guys are gonna love it. So I have a bunch ready for tomorrow. But I'm gonna go now. We're gonna be late on finishing OJ because of this stupid power outage. That's okay. Life happens. Roll with it, guys. Roll with it. Hope you guys stay warm. But not like here, man. It's so hot. I'm dying. Hope you guys stay warm and you don't have to shovel too much. And I shall see you all in a couple hours, or maybe you could just sleep instead. You will not hurt my feelings the slightest bit if you don't make it to both streams, okay? Encore. I love you, Jude. I do. Jude, you make me smile all the time. You know that? All right, guys. Bye, Nina. Guys, have a great night. Thank you. Q, cheese ball. I got you, Zach. Don't worry.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide.